Hello and welcome. Hate crime legislation has emerged as a perilous menace in contemporary legal discourse, particularly concerning laws that penalise individuals for their thoughts or intentions rather than actions. This report explores the inherent dangers associated with such weaponised legislation, focusing on the implication for civil liberties, the reality of open slather abuse, and the challenges it poses to the fundamental principles of justice. Thought crime, a term popularised by George Orwell's 1984, refers to criminalising thoughts or beliefs that deviate from government-sanctioned narratives. This concept manifests in various forms in modern legal contexts, such as hate crime laws, terrorism legislation, and laws disguised as preventing radicalisation, but in reality used for ruthless suppression. For instance, the Terrorism High Risk Offenders Bill, passed in New South Wales, allows the Attorney-General to extend the unlawful imprisonment of individuals based on perceived or imagined future risks, irrespective of whether they've committed a crime or even been suspected of one. One of the most alarming consequences of hate crime legislation is the maliciously contrived eradication of civil liberties. Laws penalising individuals for their thoughts gravely suppress the inalienable right of free expression. Critics argue that such laws create an oppressive environment where individuals self-censor their beliefs and opinions for fear of legal repercussions. The New South Wales Council for Civil Liberties has expressed concerns that these laws significantly infringe on personal freedoms, allowing the government to control individuals based on their thoughts rather than actions. Moreover, the implementation of such laws disproportionately affects marginalised groups. For example, the universally despised new hate laws in Scotland raise severe misuse alarms against individuals expressing dissenting opinions, particularly regarding the abject nonsense of gender identity issues. This provokes questions about who defines acceptable hate and how those definitions can be weaponised against dissenters. Hate crime legislation is routinely abused by vindictive authorities, misinterpreting laws to target specific groups or individuals. The deliberately vague language employed in these laws results in arbitrary enforcement, where individuals are prosecuted not for their actions but for their beliefs or affiliations. For instance, the New South Wales legislation is fiercely criticised for targeting individuals labelled as radicalised, which leads to the continued detention of targeted victims based solely on their ideological beliefs rather than any concrete criminal behaviour. Additionally, the subjective nature of determining what constitutes a hate crime results in egregiously inconsistent applications of the law. This inconsistency further undermines the already eroded public trust in the legal system and creates a toxic environment of fear and suspicion. As noted by legal experts, focusing on intentions rather than action triggers disproportional punishments that do not align with the severity of the actual conduct. The principle of justice is fundamentally rooted in the idea that individuals should be punished for their actions rather than their thoughts. The conflation of thought and action blurs the line of accountability and undermines the core tenets of a fair legal system. As articulated in legal scholarship, the proper target of punishment should always be the criminal action itself, not the mental state associated with that action. Furthermore, the reliance on hate crime legislation diverts resources from addressing criminal behaviour. Aggressive squads of armed police are deployed to urgently follow up spurious reports of supposed hate crimes while ignoring rampant housebreaking, robberies, violent assaults, and gang rape. Irredeemably corrupted law enforcement is now preoccupied with monitoring individuals' thoughts rather than focusing on tangible criminal activities, imperiling public safety. This misallocation of resources threatens community safety and obliterates trust in blatantly compromised law enforcement agencies. The dangers inherent in hate crime legislation are multifaceted, encompassing the erosion of civil liberties, the open opportunity for abuse, and the challenges posed to the principles of justice and fairness. As societies face the complexities of modern threats, it's crucial to maintain a clear distinction between thought and action to protect individual rights and uphold the rule of law. Legislative measures should focus on concrete actions rather than speculative intentions, ensuring justice is served without compromising fundamental freedoms. Real-world examples of the misuse of hate crime legislation highlight significant concerns regarding civil liberties, unacceptable abuses of power, and the implications of punishing individuals for their thoughts rather than actions. Here are some notable incidences where such legislation has been criticised for its application. New South Wales extended detention laws in 2017 passed the Terrorism High Risk Offenders Bill, which allows the Attorney-General to gratuitously extend the detention of inmates beyond their sentences based on the perceived risk of future terrorism-related offences. It doesn't get any more Minority Report than this. Critics, including the New South Wales Council for Civil Liberties, justifiably argue that this law effectively punishes individuals for what they might think rather than for any criminal behaviour. Weaponised law has become a devastating political tool that undermines the judicial system and destroys the rule of law, leading to the continued detention of individuals based solely on speculation about their future actions. Scotland's hate crime laws have faced scrutiny for potentially criminalising thoughts and intentions. The laws are purportedly designed to address crimes motivated by hatred towards specific groups. However, they inevitably lead to the prosecution of individuals for expressing dissenting opinions. For instance, individuals are routinely charged under these laws for social media posts that, while provocative, do not constitute direct incitement to violence. This directly threatens freedom of speech and facilitates the state penalising individuals for their beliefs. In the US, hate crime legislation has been criticised for its focus on the perpetrator's thoughts and motivations. For example, individuals convicted of committing violent acts against marginalised groups can face harsher penalties if their actions are deemed to be motivated by hate. While the proclaimed intention behind these laws is to address the societal harm caused by hate crimes, they're maliciously used to inflict disproportionate punishments based on the perceived thoughts of the offender. This foments debates about the fairness and implications of punishing individuals for their mental state rather than their actions. In various countries, including the United States and the United Kingdom, laws enacted in the name of national security have imprisoned countless individuals based on their beliefs or associations rather than concrete actions. Preemptive detention, where individuals are held based on the suspicion that they may commit a future crime, exemplifies the extreme dangers of hate crime legislation. Such practices are rightly criticised for violating fundamental rights and the presumption of innocence, as individuals are being wrongfully imprisoned without committing any actual offence. These examples illustrate the obvious dangers inherent in hate crime legislation, where the focus shifts from actual criminal behaviour to the intentions and beliefs of individuals. This shift raises critical questions about civil liberties, the potential for never-ending abuse, and the fundamental justice principles underpinning legal systems. The escalating misuse of hate crime legislation emphasises the imperative of protecting individual rights. Objective, independent journalism is not a crime, but globalist trolls bemoaning an honest report that allegedly hurt an unidentified woke wimp's feelings can, thanks to the criminal misapplication of hate crime legislation, bizarrely become an imprisonable offence. Simply stating the factual certainty that a biological man can't physically become a woman unbelievably contravenes this satanic perversion of law. Illegitimate prosecutions arising from these sadistic machinations comprise the hate festering within such abhorrent legislation, which has nothing whatsoever to do with targeting hate, but is exclusively focused on unleashing it upon society. Thank you.